This video is made for educational purposes only and cannot be taken as legal advice. In this video we are going to take a look at common law defense for self-defense. Always remember, knowledge is power. When we have knowledge on self-defense, although something physical, we instantly have power over those with the intention to harm us. R.V. Gladstone Williams, 1984. The appellant witnessed a man attack a youth. He rushed to the aid of the youth and hit the attacker. In fact, the youth had just committed a mugging and the attacker had wrestled him to the ground to prevent him escaping. The appellant was convicted of ABH under S.47 of the Offences Against the Person Act 1861. He appealed, contending that the trial judge gave a misdirection to the jury in requiring the mistake to be a reasonably held mistake. Held. The appeal was allowed and the appellant's conviction was quashed. Lord Lane C.J. The reasonableness or unreasonableness of the defendant's belief is material to the question of whether the belief was held by the defendant at all. If the belief was in fact held, its unreasonableness, so far as guilt or innocence is concerned, is neither here nor there. It is irrelevant. Were it otherwise, the defendant would be convicted because he was negligent in failing to recognize that the victim was not consenting or that a crime was not being committed, and so on. In other words, the jury should be directed first of all that the prosecution have the burden or duty of proving the unlawfulness of the defendant's actions. Secondly, if the defendant may have been laboring under a mistake as to the facts, he must be judged according to his mistaken view of the facts. Thirdly, that is so whether the mistake was, on an objective view, a reasonable mistake or not. In a case of self-defense, where self-defense or the prevention of crime is concerned, if the jury came to the conclusion that the defendant believed, or may have believed, that he was being attacked or that a crime was being committed, and that force was necessary to protect himself or to prevent the crime, then the prosecution have not proved their case. If, however, the defendant's alleged belief was mistaken and if the mistake was an unreasonable one, that may be a powerful reason for coming to the conclusion that the belief was not honestly held and should be rejected. Even if the jury come to the conclusion that the mistake was an unreasonable one, if the defendant may genuinely have been laboring under it, he is entitled to rely upon it. Beckford v. the Queen, 1988, Privy Council. The appellant was a police officer. He was issued with a shotgun and ammunition and sent with a number of other armed police officers to a house. According to the appellant, a report had been received from Heather Barnes that her brother Chester Barnes was terrorizing her mother with a gun. Heather Barnes, however, denied that she had made a telephone call to the police or that her brother was armed. The appellant said that on arriving at the house, he saw a man run from the back door with an object which appeared to be a firearm. As the police followed him, the appellant stated that Barnes fired at the police. In response to this, he fired back, shooting and killing Barnes. In fact, no gun was ever found. The trial judge directed the jury. A man who is attacked in circumstances where he reasonably believes his life to be in danger, or that is in danger of serious bodily injury, may use such force as on reasonable grounds he thinks necessary in order to resist the attack, and if in using such force he kills his assailant, he is not guilty of any crime even if the killing is intentional. The jury convicted him of murder, which carries the death penalty in Jamaica. He appealed, contending the judge was wrong to direct that the mistake needed to be reasonably held. The appeal was allowed and the conviction was quashed. The test to be applied for self-defense is that a person may use such force as is reasonable in the circumstances as he honestly believes them to be in the defense of himself or another.